So welcome to Jumbo IS and welcome to our lecture series called Prelims Powerplay. In this lecture series, we cover the entire 1 year's current affairs, and these current affairs are divided into subjects and we cover each and every subject one by one. Currently, we are covering Polity series. Now, the thing is that we haven't been quite regular in the last few days, and there is a reason for that. As you know, the situation is pretty tense as far as India-Pakistan are concerned, and because of that, there have been blackouts in our area. So that really makes it difficult for me to manage this studio. Okay, so that is why we have been fairly irregular. But now that we have signed the ceasefire agreement and things have calmed down, well, we'll be fairly regular, and this time we'll be a little aggressive also as far as the dropping of lectures are concerned. Okay, so lectures would be dropped almost twice every day so that we get to cover the entire 1 year's current affairs, important topics, well, before your prelims examination. Okay. Now, the thing is that we are covering Polity series, and yesterday we started with criminal justice system. So we are going to continue with that. Okay, there were a few topics that were left that might be asked in your prelims examination this year. So we will be covering those topics. So let's start with criminal justice system. Okay, without further delay. So criminal justice system once again. Now, the thing is, just a second. Yeah. So these are the subtopics that we shall discuss that are within criminal justice system. Okay, so these are the topics that we are going to discuss in criminal justice system. The issue of death penalty. As you all know, the brutal rape of a doctor in Kolkata basically started or ignited this debate on death penalty. So this entire issue of death penalty came into being. Okay, whether it should be completely banned or how it should be basically awarded or given. Okay. So the issue of death penalty, we'll talk about various important points with respect to that, from which questions might be asked. Basically, that's my aim. Okay. Then we'll talk about the concept of open jail. Okay. There are open jails in India. Open jail means that a person will be in jail but can go out to work during the day and come back in night. Okay. That is a concept and it exists in India. So concept of open jail. Then electronic tracking of undertrials. That is an issue that is being debated and it has been advised also. So we will talk about this issue. And in the end, we'll talk about the new criminal laws. Okay, the new laws which basically replace the colonial era laws. Bhartiya Nyaya Sanhita, Bhartiya Nagrik Suraksha Samhita. Okay, and Bhartiya Sakshay Adhiniyam. Okay. So these laws which have replaced, well, CRPC, Civil Procedure Code and Indian Evidence Act, basically. Okay. So we'll talk in brief about these laws because these were the new developments or these were the developments in the last year and questions might be asked from this. Okay. So we'll talk about this. Okay. So let's begin today's session with topic number 1, and that is issue of death penalty. Now, the thing is that death penalty all over the world is a debatable topic. Now, the thing is, in the olden days, okay, like 100 or 200 years back, death penalty was awarded in almost every country for different crimes. But as we enter 20th century and in 21st century, many countries have banned death penalty. Okay, some countries argue that this is a violation of human rights. Right to life is a fundamental right. And if your purpose is punishing a person for a crime committed by them or him or her, okay, then you should jail them for life. But death penalty is a draconian law. It is violation of human rights and death penalty should be banned. Now, some countries in Europe and elsewhere have banned death penalty. Now, there have been attempts in India in the past. There have been cases, petitions filed in the Honorable Supreme Court to ban death penalty. But Supreme Court has taken a stand. And that stand is that we cannot ban death penalty. Okay. But yes, Supreme Court has added some safeguards. What are those safeguards? We'll talk about that. Okay. So the issue of death penalty. So what is the situation in India? Now the thing is, in India, death penalty is not banned. Okay. Death penalty is not banned. But the Honorable Supreme Court has said that it should be awarded in rarest of rare case. Okay, rarest of rare case. And this is also known as rarest of rare doctrine. you should award death penalty only in rarest of rare cases. Now, when did Supreme Court gave this rarest of rare doctrine? In Bachchan Singh versus State of Punjab. The Supreme Court has held that a sentence of death should be passed only in the rarest of rare cases after the court has considered possible aggravating and mitigating circumstances. Okay. Now, in Bachchan Singh versus State of Punjab, they said it should be awarded only in rarest of rare cases, but death penalty can't be banned. In fact, Bachchan Singh versus State of Punjab was basically a case in which people were arguing banning death penalty altogether. Okay, the case was also a little more than this, but the Supreme Court said we cannot ban death penalty altogether, but we will award it in rarest of rare case. Now, how would you decide whether a particular case is rarest of rare or not? What qualifies as rarest of rare case? So, to decide for that, the Supreme Court gave certain circumstances. Okay, aggravating circumstances, mitigating circumstances. If these aggravating circumstances exist, then death penalty should be awarded. Then it would qualify as rarest of rare case. Okay, and if there are mitigating circumstances, if these circumstances exist, okay, then you would not award death penalty, you would give life imprisonment or whatever sentence you want to give, but that would move away from death sentence. Okay, now what are these aggravating circumstances? What are these mitigating circumstances that are given by the Honorable Supreme Court? Well, here they are. So remember, first let's talk about aggravating circumstances. So by aggravating circumstances, Supreme Court says that if any of these things exist, circumstances exist, then decision should be made in favor of death sentence. Now, what are these aggravating circumstances? Supreme Court actually gave a list. First of all, if the murder is pre-planned and calculated and of extreme brutality. So if it is a cold-blooded murder, it was pre-planned, it was properly calculated, it was not crime of passion that you were angry and you killed someone, and it was of extreme brutality. Then, if there is exceptional depravity, okay, exceptional weirdness to your murder, okay, like the case in Kolkata, okay, or if you murdered a public servant, police personnel, or person of armed forces while they were performing their duty, then that would qualify as death sentence, aggravating circumstances. Then there are a few mitigating circumstances that would rule in favor of life imprisonment and not death sentence. Okay, these are influence of emotional and mental disturbance. So if a person is emotionally disturbed or mentally disturbed and then he committed that crime, then Supreme Court can think that we shouldn't award death sentence to that person. You also look at the age of the accused. If the person is very young, okay, 18, 19, 20 years of old, or very old, so age of the accused is taken into account. Then, if you are sure that in jail this person can reform, okay, if you feel that you can reform this person through jail time, he doesn't need to die, he will realize his mistake. If there is probability of reform, then if the accused was acting on the directions of some other person, there was some other conspirator on whose direction this person was acting, then not death sentence, not. If the person believed that whatever he did was morally justified and he gave a moral argument for that, then. And if you feel that this person is a threat to society, if there is a high probability for this person being a threat to society, whether in jail or outside jail, then death sentence can, well, if he's a threat, then death sentence can be awarded. If threat is low, then mitigating circumstance. Clear? So here is the list of aggravating and mitigating circumstances given by Honorable Supreme Court in Bachchan Singh versus State of Punjab case 1980. Though after that, many other judgments of the Supreme Court have come out, okay, and those have added to this list of aggravating and mitigating circumstances, but we need not get into that. Clear? That would be all. Now let's quickly jump to topic number 2, which is concept of open jails. Now, the thing is that in our country, there is a problem with respect to jail management. And what is that problem? It is said that our jails are overcrowded. They are overcrowded. We cannot manage. The capacity is not enough to manage the number of people who are coming into jails. Plus, it is argued that 75% of the jail inmates in jails are under trials. What do you mean by under trials? Under trials are those people, well, who are not basically convicted. Okay, their case is still going on. Their case is still going on, and court has not taken a final call on whether this person is guilty or not. His case is still going on. But for preventive measures, he has been detained in jails. Those people are called under trials. If his case is finally decided and he's acquitted, then he will go scot-free. No final decision has been given on him. 75% of the people in our jails are under trials. They're waiting their decision in the courts of India. Okay, now this is a problem. What if there are some people who have committed minor crimes, are not that big of a threat to the society if they're outside? Okay, we should basically unburden our jails with this overcapacity. Plus, these people who have committed minor crimes and are not threat to society, we should allow them some freedom. Here the concept of open jails is there. Okay, emanates basically. Now in open jails, there is a particular locality in which people are jailed. Well, they can go out of the jail, work on farm fields, go to their job and come back in the evening. Okay, they come back in the evening and they can even bring their families, they can do whatever. I mean, there are different rules in different states, but generally it is like that they are allowed some freedom to go out, some freedom to live with their family and all that. Now, this concept of open jails should be propagated more if we really want to unburden our jails. Plus, if we want to give proportionate punishment. Okay, by proportionate punishment, I mean that if people who have committed minor crimes, they shouldn't be put under strict imprisonment. Make sense? So, this is the concept of open jails. Okay, so let's talk about what is the legal situation, what are the laws with respect to open jails. Clear? So the concept of open jails. Okay, now the thing is that when we talk about jails, okay, just remember this, jails is a state subject. That means only state governments are allowed to make laws on it. State assemblies, I mean. Okay, jails is a state subject, and that is why different jails, different states have different jail rules also, jail manuals also. Because it is a state subject, only state assemblies are allowed to make a law. But the parliament has enacted Model Prisons and Correctional Services Act. Now, why is the word model added over here? Since parliament knows that the prerogative of making a law on jails lies with the state government or state assemblies, parliament cannot enact a law. But parliament can enact a model law which state assemblies can use or enact themselves. So this is a model basically which state assemblies can apply to themselves by enacting a law similar to this. Clear? That's why parliament has enacted this. So remember this, jails is a state subject. Now, as per Model Prisons and Correctional Services Act 2023, well, a definition of open jails is given. Okay, what is that definition? So open jail is a place for confinement of eligible prisoners on such conditions as may be prescribed under the rules of jail rules. For giving them more liberty outside a regular prison, they can go out, for facilitating their rehabilitation after release. So the purpose is to give them more freedom, and when they'll get released, they won't feel so out of touch with society. Generally, it happens with people who come out of jails after a long time. It becomes very difficult for them to connect with the society outside because they're so habitual of residing in jails. So to stop that, basically, people in open jails are given some freedoms to operate outside and then come back. Okay. Now, since jails is a state subject, different states have different rules for open jails. Okay. Like I said, open jails will have such conditions, whether a person can go outside from 9 a.m. to 2 p.m. or 9 a.m. to 5 p.m. There are different rules in different states. Clear? States have their own criteria to select people for open jails also. Who will go to open jail? Different states have different criteria. That criteria is generally based on the nature of their crime. If it's a minor crime, then their behavior in normal jails, their conduct in normal jails. Okay. So on basis of these different criteria in different jails, people are selected for open jails. Okay. Open jails have minimum security and convicts are permitted to venture out for activities including agriculture. Now the purpose is it helps reducing overcrowding in jail. Yes, that's the prime purpose. And makes it easier for prisoners to reintegrate into society once they're out. Because they have been habitual of going out, interacting with people and all that. Clear? Now, as far as India is concerned, the first open jail in India was set up in 1949, in independent India basically, in Lucknow. Then, a committee was established in 1980-83 called All India Committee on Jail Reform, also known as Justice Mullah Committee, because this committee was under the chairmanship of Justice Mullah. Okay, it states that it was in 1952 at the Hague Conference, International Hague Conference, that the organization of open air camps was suggested. So India had open jails in 1949, but for the very first time in international arena, the concept of open jails was discussed in 1952 in Hague Conference. Okay, this Mullah Committee, Justice Mullah Committee, said there were back then in 1980-83 28 to 30 open air jails in India. So back in 1980s, there were around 30 open jails in 13 states. Clear? So Mullah Committee, Justice Mullah Committee advised other states to enact open jail laws or allow for rules for open jail. Okay. Now, if we come to today, currently, as per Prison Statistics of India, 2022, India has 91 open jails in 17 states with a capacity of 6,000, around 6,000 inmates over 4,473 prisoners. Now, this is not important. What is important is Rajasthan has highest number of open jails, followed by Maharashtra. Clear? That's all. That's all you need to know as far as the concept of open jails is concerned. Now let's quickly shift our focus to electronic tracking of under trials. Okay. Now there is a debate. Again, like I said, overcrowding of prisons is a problem. Okay. And most of these people in jails are under trials. So a suggestion was given. Okay. That suggestion was that some of these under trials can be released on bail, because their case is still being decided. So they are not final criminals. So they can be released on bail. Okay. But the thing is that they would be electronically tracked. So on their feet, there will be an electronic tracker, and these people, these under trials would be released so that police can track them, whether they don't run away or basically that's the reason. So this electronic tracking should be allowed. Currently, it's not allowed. This electronic tracking should be allowed so that more and more under trials are given bail, but the police is able to track them, but they are given bail, and our jails get basically decongested. Overcrowding, the problem of overcrowding gets solved basically, right? So that is why this issue of electronic tracking of under trials was basically discussed. Okay, but last year Supreme Court basically struck this down. Okay, Supreme Court said no, electronic tracking of under trials shouldn't be allowed. Electronic tracking of bail people who are out on bail shouldn't be allowed, because if you're tracking them electronically, then you are breaching their right to privacy, and that is a fundamental right as per a Puttaswamy judgment a few years back. Right to privacy is a fundamental right, right? So Supreme Court said that if you are going to electronically track people out on bail, that would be breach of fundamental rights, right to privacy. So Supreme Court basically did not entertain this argument. But recently, many reports have been published which say that we should do this, we should think about this, because there are a lot of advantages to this. Plus, the first and foremost, the most important advantage is it would decongest our jails, right? So this is the issue of electronic tracking of under trials. All right. Now, recently, President of India released a report. That report was written by Supreme Court Center for Research and Planning. So Supreme Court has a Center for Research and Planning. This Center for Research and Planning in Supreme Court basically authored this report. The name of the report was Prisons in India, Mapping Prisons Manuals, prison manuals and measures for reformation and decongestion. So in this report, they basically gave some suggestions how we can basically improve the prison rules in prison manuals and decongest our jails. Okay. Now they have suggested that we should think about electronic tracking of under trials. Okay. Despite the fact that the Supreme Court has basically said it is not possible, it is breach of fundamental rights, Supreme Court should rethink, okay, and it should be allowed. Clear? Now, it's not just that this report has said that electronic tracking of prisoners should be allowed. In fact, Law Commission and Parliament Standing Committee on Home Affairs, they say that it should be allowed. Okay, because this would really solve the problem of decongestion of our prisons. Okay, but Supreme Court has said it is a violation of right to privacy. Currently, it is not allowed. Though this thing can be seen in United States of America, and basically Law Commission and Parliament Standing Committee and this report, all of them say that, well, learning from US's example, we can basically allow for electronic tracking of under trials with certain guardrails, with certain safeguards, so that right to privacy is not breached. Okay, learning from USA. Make sense? Now, as far as prison overcrowding is concerned, we have discussed this. According to National Crime Records Bureau, India suffers from significant overpopulation, 131.4% occupancy. That means more than the capacity of jails. Okay. In addition, 75.8%, that means around 76%, prisoners are under trials. Okay. The Prisons in India report suggests that electronic monitoring could prove to be a cost-effective method to decongest jails in India. Simple. And that would be all as far as this topic is concerned. And now let's move on to topic number 4, which is Bhartiya Nyaya Sanhita. So the thing is that, well, we won't discuss that much as far as this topic is concerned. I won't spend that much time as far as this topic is concerned in this lecture. Though there is some information which will be in your notes. I would want you to read those notes yourself, because those notes are self-explanatory. You will understand. And you have to remember whatever is mentioned in the notes. Okay, there is no point in discussing those things. Those things are self-explanatory. We won't waste much time. Okay, I would only like to discuss a few things with respect to this particular topic. Okay, and we would end the lecture. Clear? So look, as far as Indian criminal justice system is concerned, okay, it is governed by 3 laws in India. Okay, these 3 laws basically regulate how cases would be heard in India with criminal cases, how criminal cases would be filed in India, how FIRs would be registered, how evidence would be presented, what laws, what constitutes crime, what would be considered criminal in our country. Okay, all these things are governed by 3 laws. Okay, what are those 3 laws? Law number 1 was Indian Penal Code, which was enacted by the British in 19th century. Okay, then there was Indian Evidence Act. How evidence shall be presented, what is evidence, okay. Indian Penal Code basically lists down the crimes which are punishable, okay. Indian Evidence Act, again 19th century. And then in 20th century, we ourselves enacted CRPC, Criminal Procedure Code, how courts would hear cases. Now, most of these laws or most of these provisions were colonial era provisions. Now, the problem with colonial era was, very simply put, well, these were old. These laws were enacted based on the society back then. Now, society has changed. There are so many redundant things. There are so many crimes that we don't consider crime anymore in 21st century. Right? So they need to be redacted, they need to be removed, and fresh crimes of 21st century need to be added. Therefore, there was a need to replace these laws. Yes. Plus, there was another need. We need to decolonize ourselves. Still, we are following those laws which were given by our British masters back then, British colonizers. We need to decolonize. So for these 2 purposes, well, we enacted 3 laws which would replace these 3 laws, the British era laws. Okay. For IPC, there was Bhartiya Nyaya Sanhita, this one. For Indian Evidence Act, okay, there was Bhartiya Sakshay Adhiniyam. And for CRPC, Bhartiya Nagrik Suraksha Sanhita. Okay. So the older provisions which are no longer relevant were removed. Okay. The laws were basically brought in sync with times of the day, okay, current conditions of India, and we also decolonized. Now, what were some of the important things? Very few points that you need to remember are mentioned in your notes. Clear? That would be all. And with that, we conclude today's session. Please do not forget to revise all of this from your notes, and please do not forget to practice MCQs. It is important. Prelims is fast approaching. Okay. On that note, I'll be signing off with the promise of seeing you again with another lecture basically on Prelims Powerplay series. Thank you, everyone.